Two missing words on your deed could cost your spouse the house. Here's how to fix it before it's too late. Two specific words are missing from the deeds of tens of millions of married American couples. And when one spouse dies, those two missing words cost the surviving spouse full ownership of the home they lived in together for decades. The two words are with survivorship. And in most states, if those words don't appear in the exact legal language of the deed, joint ownership defaults to something called tenancy in common, which means when one spouse passes away, half of the home does not automatically go to the surviving spouse. Half of the home goes through probate. This rule is not new. It's been in effect since the early part of the 20th century, codified in statute in every state in the Union. But the specific language required to trigger automatic inheritance between spouses varies by state.
And in many states, the default presumption has actually shifted away from survivorship over the last 40 years, which means deeds recorded decades ago that once carried implicit survivorship rights may no longer carry those rights under current law. So the family home that a couple bought together in 1986, paid off in 2008, and now sits on as their single largest asset can quietly fail to transfer the way both spouses assumed it would. The first time most families discover this is at the widow's kitchen table, when the title company calls to say the planned refinance can't close until the deceased husband's share is cleared through probate, or until the 3 adult children listed as heirs sign quitclaim deeds giving up their inherited interest. But the adult children don't always sign. In blended families where the deceased spouse had children from a prior marriage, those children sometimes have no legal obligation to sign anything, and their inherited half of the home becomes their property. The widow ends up sharing title with her husband's first wife's children. She can live in the home under state homestead protections in most states, but she cannot sell, cannot refinance, and cannot borrow against it without the signatures of every other owner listed on the title. The numbers on this rule are larger than most families realize. Probate fees on a home valued between $300,000 and $600,000 commonly run between $15,000 and $40,000 in combined court costs, attorney fees, and executor commissions. Contested cases in blended family situations can exceed $100,000 in legal fees alone. And the fix, when caught in time, is simple and inexpensive. A real estate attorney or an elder law attorney can review the recorded deed, identify whether the survivorship language is present, and if it's missing, prepare and record a corrected deed that adds the language for between $300 and $600, depending on state and county. The correction takes 1 to 2 office visits and roughly 2 weeks of recording time, but the correction must be filed while both spouses are alive and have legal capacity, because once one spouse dies or once either spouse loses the capacity to sign, the window to fix the deed closes permanently. So the rule is knowable, the fix is cheap, and the stakes are the family home. The families who lose the home are almost always families who never thought to pull the deed and read it. The legal distinction between joint tenancy and tenancy in common. The legal distinction between joint tenancy with right of survivorship and a tenancy in common is one of the most consequential distinctions in American property law, but it's also one of the least well-known among the homeowners it affects most. Joint tenancy with right of survivorship, commonly abbreviated as JET-ROS, is the form of co-ownership that most married couples assume they have when they buy a home together. Under this form of ownership, the first spouse to die automatically transfers their interest to the surviving spouse, outside of probate, by operation of law. The surviving spouse becomes the sole owner at the moment of death, and the change in ownership requires only a death certificate and, in some states, a short affidavit filed with the county recorder. Tenancy in common is the alternative, and in most states, it's the default form of ownership when co-owners are named on a deed without any specific survivorship designation. Under tenancy in common, each owner holds a fractional interest, commonly 50% for 2 owners. When one tenant in common dies, their fractional interest does not transfer to the surviving co-owner. It becomes part of the deceased's estate, passes through probate, and is distributed according to the deceased's will, or, if there's no will, according to state intestacy law. So the same two people owning the same home together can be in radically different legal positions, depending solely on whether the deed contains the phrase mole with right of survivorship, or whether it does not. If the deed names both spouses without survivorship language, the default in most common law states is tenancy in common, and the surviving spouse inherits nothing automatically. Durasir. The state-by-state variation in survivorship language. But there are complications layered on top of this basic rule. In some states, joint tenancy is presumed by statute to include survivorship rights unless the deed specifically says otherwise. In other states, joint tenancy without survivorship language is treated as tenancy in common by default. In community property states, the rules are different again, because community property between spouses has its own transfer on death mechanism that operates independently of joint tenancy. A handful of states preserve the common law presumption that joint tenancy between two named owners carries implicit survivorship rights, even without the exact phrase appearing in the deed. But roughly half of the states have statutorily abolished that presumption and require the specific phrase, with right of survivorship, to appear in the deed, or the ownership defaults to tenancy in common. The remaining states fall somewhere in between, with varying presumptions, varying exceptions for spouses, and varying treatment of deeds recorded before specific statutory changes. And the language used in historic deeds is not always what current law requires. A deed recorded in 1978 in Pennsylvania may have used the phrase, quote, as joint tenants, which under Pennsylvania law at that time carried implicit survivorship rights for married couples, but no longer does under current law. The deed itself didn't change, but the legal effect of the deed changed when the statute changed. And the couple who recorded it in 1978 may have no idea that the law has moved out from under their paperwork. What happens when survivorship language is missing? When the deed doesn't carry survivorship language and one spouse dies, the immediate legal consequence is that half of the home becomes part of the deceased's probate estate, and that half is distributed according to the deceased's will, or if there's no will, according to state intestacy law. The surviving spouse does not automatically inherit the deceased's half. Whether the surviving spouse eventually receives that half depends on what the will says, whether there are other heirs, whether any of those heirs choose to contest or reject the distribution. In straightforward cases where the deceased had a will that left everything to the surviving spouse, the probate process still runs. But it ends with the surviving spouse as full owner of the home. The cost in that simple case is the probate filing fee, the executor's commission, and whatever legal fees accumulate during the probate window, which in most states runs between 6 months and 18 months. On a home worth $400,000, probate fees in the range of the $15,000 to $30,000 are common, before accounting for any creditor claims that get filed during the notice period. But the straightforward case is not the case that destroys families. The cases that destroy families are the cases where the deceased spouse had children from a prior marriage, the deceased spouse died without a will, the deceased spouse's will is ambiguous, a creditor surfaces with a claim against the deceased's half of the home during the probate window. Dacus. A real-world case, Ellen's story. Consider the case of a widow named Ellen, who lived in her Ohio home for 41 years. The deed, recorded in 1985 when Ellen and her husband bought the home, named them as joint tenants, without the phrase, with right of survivorship. Ohio law at the time, and today, defaults that ownership structure to tenancy in common unless the exact survivorship language is included. When Ellen's husband died, his half of the home did not automatically pass to Ellen. His will, drafted 30 years earlier and never updated, left his real estate interests equally among his 3 children, one of whom was Ellen, and 2 of whom were his children from his first marriage. So Ellen, as a named child in the will, inherited 1/3 of her husband's half, which is 1/6 of the home. The 2 children from the first marriage each inherited 1/3 of her husband's half, which is 1/6 each. Ellen's original half was still hers, but after probate, the home was owned, 1/2 by Ellen, 1/6 by Ellen again, through her inherited share, 1/6 by her husband's first wife's son, 1/6 by her husband's first wife's daughter. Ellen's total ownership was 2/3. The other third belonged to the other two children. Ellen could continue living in the home under Ohio's homestead protections for the surviving spouse. But she could not sell, could not refinance, and could not borrow against the equity without the signatures of both other owners. One of those other owners refused to sign a quitclaim back to Ellen because his own family was going through financial difficulty, and he considered the 1/6 interest a significant asset. The second owner was willing to sign, but was not willing to accept a quitclaim without compensation in the range of $50,000, which Ellen didn't have in liquid savings. The home, valued at $620,000 at the time of Ellen's husband's death, effectively became an illiquid asset that Ellen could live in, but could not access the equity of. Ellen's options narrowed to selling her own 2/3 interest to a third-party investor at a discount, negotiating a family settlement that drained her retirement accounts, filing a partition action in court that would force a sale of the entire home and distribute the proceeds according to the ownership percentages. Ellen's case in Ohio settled through family negotiation rather than partition, but the settlement drained her retirement account by $80,000. And Ellen was 74 years old at the time, with limited ability to rebuild the savings before her own long-term care needs would begin. Sector O. The 5 financial costs of a missing survivorship clause. The financial cost of a deed missing the survivorship language breaks into 5 categories, and the total cost for a family in a contested case commonly exceeds $100,000 before the estate closes. Category 1. Probate court fees. These vary by state but commonly run between 2% and 7% of the value of the assets passing through probate. On a home worth $500,000, the half that passes through probate is worth $250,000, and probate fees on that amount commonly total between $5,000 and $7,500 in direct court costs, executor commissions, and required publication costs. Category 2. Probate attorney fees. These are usually charged hourly and commonly run between $300 and $600 per hour, depending on the state and the attorney's experience. A straightforward probate with no contested claims commonly takes between 20 and 40 billable hours, which produces a fee range between $6,000 and $24,000. A contested probate, especially a blended family dispute over the home, routinely exceeds 100 billable hours, which produces fees between $30,000 and $60,000, and in heavily contested cases, over 6 figures. Category 3. Delay cost. Probate in most states takes between 6 months and 18 months, during which the home cannot be sold without court approval, cannot be refinanced, and cannot be used as collateral for a loan. In a rising interest rate environment, the inability to refinance during probate can cost a family tens of thousands of dollars in higher carrying costs. In a falling market, the inability to sell during probate can lock the family into a home whose value is declining faster than the mortgage is being paid down. Category 4. Creditor claims. During probate, any creditor of the deceased has the right to file a claim against the estate within a notice period that varies by state, between 3 months and 12 months. Medical bills, credit card balances, unpaid taxes, and in some states, unpaid long-term care costs can all be satisfied out of the deceased's assets, including the half interest in the home. If the deceased had significant debts, the home's value can be substantially reduced before the surviving spouse or other heirs ever see title clear. Category 5. Partition litigation. When co-owners can't agree on how to handle the inherited shares, any single co-owner can file a partition action, which is a court order to either physically divide the property or, more commonly, force its sale and distribute the proceeds according to the ownership percentages. Partition cases commonly take between 18 months and 3 years, cost between the $20,000 and $80,000 in legal fees, and frequently result in a forced sale at a price 20% to 30% below market value because of the time pressure and the distressed nature of the sale. That's your how to fix the problem. The corrective deed. The correction process is mechanically simple, but it has to follow specific rules, or the corrective deed is invalid and provides no protection. The process begins with the existing deed, which establishes the current ownership structure, and ends with a newly recorded deed that either adds the missing survivorship language or replaces the existing deed with a new deed that carries the correct language from the start. The most common correction is a quitclaim deed, from both current owners to both owners, as joint tenants with right of survivorship. Under this approach, the two spouses who currently own the home as tenants in common, or as joint tenants without survivorship, execute a quitclaim deed that transfers the property from themselves to themselves under the corrected form of ownership. The quitclaim is signed by both spouses, notarized and recorded at the county recorder's office. The cost is the attorney's fee for drafting, which commonly runs between $200 and $400, plus the recording fee, which in most counties runs between $30 and $80. The 3 action steps you need to take this week. The action step is straightforward, but it's not a single action. It's 3. Step 1. Pull the deed. The recorded deed is available at the county recorder's office in the county where the home is located. Most counties now provide online access to recorded documents through the county recorder or clerk's website. If the online search doesn't return the deed, the county recorder's office will provide a certified copy for a small fee, commonly between $1 and $10 per page. Before the attorney consultation, pull the deed and note the exact language that describes how the owners hold title. Step 2. Consult with a real estate attorney or estate planning attorney. The attorney should be licensed in the state where the home is located. Specifically, ask the attorney to review the deed language against the current statutory framework for joint ownership and survivorship in that state. The consultation fee commonly runs between $75 and $200, and in many cases, the attorney will waive the fee if a corrective deed is subsequently ordered. The attorney should tell you in 1 or 2 sentences whether the existing deed language carries automatic survivorship rights under current law, and if not, what the corrective instrument should be. Step 3. Execute and record the corrective deed while both spouses are alive. The drafting and recording fee commonly runs between $200 and $600, and the filing is complete within 2 to 6 weeks, depending on the county recorder's workload. Every tool requires both spouses to have capacity at the time of execution, and every day that passes without the correction increases the probability that a health event will close the window permanently. Final thoughts. The home is the single largest asset most American families own. The legal instrument that transfers the home at death is the deed, not the will. And the deed's effect depends on specific statutory language that varies by state and changes over time. A deed that worked under the law of 1978 doesn't necessarily work under the law of today. And the first time most families discover the gap is at the widow's kitchen table, on the day after the funeral, when the title company calls with bad news. The correction is inexpensive. The failure is not. The 2 words are with survivorship. Pull the deed. Find out if they're there. And if they're not, fix it this month, while you still can.